Thank you, Bill. Actually, Bill gave my whole speech, so really there's not much left for me to say. But I am going to talk to you today about Massachusetts v. EPA, which is the case that Bill mentioned. But first I want to say thank you to Dean Jeffries for the opportunity to speak to you, and thanks to all of you for your work in making this institution great and keeping it great over these many years. So Massachusetts v. EPA decided on April the 2nd was the court's first case addressing climate change. And the decision was an enormous victory for environmentalists for two reasons, basically. It legitimized their concerns about climate change, and it legitimized their claims that the administration wasn't doing what it should to address climate change. Whether the decision was a great victory for the environment, I think, remains to be seen, and I'll talk some about that at the end. But the decision will certainly figure strongly in the policy debate that will happen over the next several years. For me, as Bill mentioned, the decision had a special personal significance, and I'll talk about that a little and then go on to make some general comments about the court's decision. I'll try to be balanced, but please keep in mind that I do have a dog in this fight, and that will probably be all too obvious as I tell you what I think about the case. So for me, the story begins on a day in March 1998 at hearings before the House Appropriations Committee. The administrator of EPA, Carol Browner, then was defending her budget before the committee, and I was sitting behind her along with a bunch of other of her lieutenants. These are the wooden-faced people you see on C-SPAN broadcasts and wonder what they are doing there. What they are doing is hoping desperately that they don't get bounced a question that they can't answer. That day, something unusual happened. Congressman DeLay was a member of this committee. He came in to the committee room with a document, and he was looking at the document in a way that made it pretty clear that he was annoyed with something in the document. The document, it turned out, was an EPA report, which contained a sentence to the effect that EPA had authority to regulate emissions of a number of substances from electric power plants, including carbon dioxide, a greenhouse gas. And when it came his turn for questions, Congressman DeLay asked the administrator whether she agreed with that sentence, and particularly the unprecedented claim, in his view, that EPA had authority to regulate emissions of carbon dioxide. She answered yes, she did agree, and she would be happy to have me provide a legal opinion on this point. Now, I had never discussed this issue with her before that moment, but there appeared to be no doubt about what the legal opinion would conclude. As it turned out, the opinion was not hard to write. The Clean Air Act says that EPA must regulate a substance if it is an air pollutant, and if the administrator finds that emissions of it will endanger human health and the environment. The statute defines air pollutant with astounding breadth as, and I'm quoting here, any air pollution agent, including any physical, chemical, or biological substance or matter which is emitted into or otherwise enters the ambient air. I think the real question under that standard is what's not an air pollutant. Anyway, I concluded that CO2 and other greenhouse gases qualified as air pollutants when emitted into the air, and that EPA was bound to regulate them if it found that they met the endangerment standard. Although it seemed pretty straightforward to me as a legal matter, this opinion met with considerable skepticism, indeed derision in some circles. There was an ad developed by the Competitive Enterprise Institute that started out with images of, this is a television ad, started out with images of happy people walking in the parks, running on the beach, enjoying their lives in their lighted houses and apartments. And a narrator in the ad comments that CO2 is essential for life, and that the fossil fuels that produce CO2 have saved us from lives of back-breaking labor and enabled us to care for the people we love. And then the voice turns a little darker here and says, but now some want to label CO2 a pollutant. What will happen if they succeed? And then there's an image of a young girl. She's innocently blowing seeds from a dandelion head. It's really a beautiful picture. And then that image suddenly goes dark, and there's the punchline. And the punchline is carbon dioxide. They call it pollution, we call it life. And you know pretty much who the we and the they are in that, right? I was the they. In 1999, after I left EPA to come to this wonderful place, a coalition of groups filed a petition to EPA to regulate greenhouse gas emissions from new motor vehicles under Title II of the Clean Air Act. They relied on my opinion as the legal basis for their petition. In 2003, while that petition was still pending, a new EPA General Counsel reversed the 1998 opinion, concluding that the agency did not have authority under the Clean Air Act to regulate greenhouse gas emissions. Did I say that there was a change in administrations during this? So soon after that, EPA denied the rulemaking petition on the grounds that it didn't have authority, regulatory authority to act, and even if it had the authority, regulating greenhouse gases at this time would be unwise. That decision was upheld by a divided panel of the D.C. Circuit, and then, somewhat surprisingly, I think, because there was no conflict among the circuits, and there was a serious threshold question about whether petitioners had standing, the Supreme Court granted review. And then last month, Justice Stevens delivered the opinion of the court, speaking for a bare majority that included Justices Kennedy, Souter, Ginsburg, and Breyer. The court concluded that at least one of the environmental petitioners, the state of Massachusetts, had standing. And on the merits it held that EPA had the authority to regulate CO2 and other greenhouse gases, and that in declining to regulate, EPA had failed to meet its statutory obligations. Chief Justice Roberts and Justices Scalia, Thomas, and Alito joined in a pair of dissenting opinions. Justice Roberts wrote to the issue of standing, and Justice Scalia wrote to the merits. So, what are we to make of the court's decision? An early commentator on the decision said this: a breathtaking result for the Greens. Stunning. The decision defines a major new area of responsibility for EPA, and it places limits on the agency in carrying out that responsibility. It also projects a sympathy with environmentalist beliefs and values to an extent rarely, if ever, seen in the Supreme Court's environmental cases. This cultural or symbolic significance of Massachusetts v. EPA is, for me, the decision's most remarkable feature, and it is to that I will now turn, begging the indulgence of my colleagues who have heard some of the ideas that I'm going to use here in other settings. What do I mean by environmentalist or environmentalist beliefs and values? People calling themselves environmentalists believe a lot of things, but there are some common themes, I think. Environmentalists share a sense of urgency. They believe that the environment is seriously threatened and that it requires attention now. They also subscribe to what I will call the ecological model, the idea that nature is fragile and interdependent, so that environmental disturbances are likely to have consequences, and those consequences may be